Hey everybody, my name is Priya and you're watching Phonology Legal. In our Indian Constitution, fundamental rights are discussed in Part 3, that is from Article 12 to Article 35 of the Constitution. And this part provides for 6 different kinds of fundamental rights. One amongst them is the right to equality, which is discussed from Article 14 to Article 18 of the Constitution. Article 14 talks about the general principles of equality. Article 15 gives us 5 grounds and prohibits discrimination on these 5 grounds. Article 16 talks about equal opportunity in public employment. I've already made videos in these 3 articles. I'll link them in the description below. In today's video, we are going to discuss Article 17. Let us see what Article 17 of the Constitution provides for. The article says, untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with law. To understand the meaning and application of Article 17, it is important that we first understand these 2 words. First, untouchability, and second, offence punishable in accordance with law. In our Indian society, the practice of untouchability is an old one, but so is the struggle against it. Before independence, that is even during the British rule, our country did witness a lot of social movements against this practice of untouchability. Jyotiba Phule, B.R. Ambedkar and Mahatma Gandhi were the leading figures of these movements. Mahatma Gandhi even went forward and said that untouchability is a sin of Hinduism. The first word and the key word of entire Article 17 is untouchability. But this word has neither been defined in the Constitution nor in any other act. Now look at this interesting overlap. The constitutional framers gave us the word untouchability but did not define it or provide for its application. How this word has to be interpreted, how this word is to be defined has been provided by the judiciary. In Jai Singh vs. Union of India case of Rajasthan High Court and Dev Rajya vs. B. Padmana case of Madras High Court, it has been held that in Article 17, the word untouchability has been placed under inverted commas, which means that this word is not to be taken by its literal or grammatical interpretation. The meaning of this word is to be derived from its historical development and historical practices. Therefore, the word untouchability under Article 17 only means caste-based untouchability. Now, Article 17 deals with the problem of untouchability in 2 ways. First, it forbids any form of untouchability. Second, it says, even after this, if any person practices untouchability, then that person will be punished as per law. Now, up till now, we know what is the meaning of untouchability and how it is forbidden. Let us get to the punishment part. Now, this is the part that is generally not taught in colleges. See, under Part 3, that is from Article 12 to 35, wherever there is a provision for an offence or prescribing of a punishment, that power has been levied under Article 35. So, for the entire Part 3, wherever punishment is to be prescribed, it can be prescribed only through Article 35. Now, Article 17 provides for a punishment. That can be done through Article 35. Let us understand it simply. What does Article 17 say? It says anyone who practices untouchability shall be punished. And what does Article 35 say? Article 35 says that for the entire Part 3 of the Constitution, if any punishment is to be prescribed, it can be done through Article 35. Now, fulfilling the provisions and mandate provided under Article 17 and 35, the Parliament passed the Untouchability Offences Act 1955, which prescribes punishment for untouchability. But later it was realized that all the provisions and punishment prescribed under the Untouchability Offences Act were inadequate. Therefore, in the year 1965, a committee was set up to revise this act. This committee was known as the Committee on Untouchability, Economic and Educational Development of the Scheduled Caste. Now, this committee came up with various recommendations. So, in the year 1976, all these recommendations were included and this act was incorporated as Civil Rights Protection Act 1955. Let us quickly have a look at the new and improved Untouchability Offences Act, that is the Civil Rights Protection Act. The major improvement was enhancement of the punishment. Along with it, all the offences relating to untouchability were made non-compoundable. If you want me to cover topics of IPC such as culpable homicide and murder, compoundable, non-compoundable, cognizable, non-cognizable, do let me know in the comment box. Moving on, the next change, a duty was imposed on the public servant. The act cast a duty on the public servant to investigate the matter. If public servant does not investigate or willfully neglects the investigation, then the Act specifies that this act of ignorance, this act of not fulfilling the duty will also be an offence, and in such a scenario, the public servant will be deemed to be an abettor to the offence. Next, places of worship are now also included under the Act. The Act says that at any place of worship, if untouchability is practiced, preached or justified, then it will also amount to an offence. Lastly, power has been given to state government to impose fines. The Act says that in any area, if a number of people are involved in discriminatory practices of untouchability, then the state government holds power to impose collective fines and punishment on those people. Now let us understand other important cases related to Article 17. In the case of People Union for Democratic Rights versus Union of India, it was said that the protection provided under Article 15 and Article 17 is available against state as well as against the private individual. So a citizen is protected against the practice of untouchability from both state and private individuals. So the application of Article 15 and Article 17 is broader than the other articles. Next is the state of Karnataka versus Appa Balu Ingle. In this case, the Supreme Court said that the objective of Article 17 is to remove all forms of disability, restriction and prohibition which are solely based on the grounds of caste and religion. Next, other than the Civil Rights Protection Act, another important legislation is the Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act 1989, which provides for punishment against untouchability. Along with it, this act also provides how the trial had to be conducted, what are the forms of relief available, formation of special courts, etc. If you still have any doubt regarding Article 17, comment down below and get it sorted. Also, if you're interested in learning Constitution in this easy manner, then you can subscribe to my course on Constitution. I'll tell you a little about the course. This course consists of 19 chapters which is spread over 60 plus topics, in which we've included discussion on important and landmark cases, recent cases, comparative constitution analysis, weekly analysis and much more. Along with all this, you'll also get access to my exclusive videos on Constitution which are only available to the members of this course. If you have any query related to this course, you can call me on this number. I hope today's discussion on Article 17 was a fruitful one. That's it for now. See you in the next class. Bye bye.